Recently, many activists, journalists and students have been booked under the Unlawful Activities Prevention Act (UAPA) in different cases across the country. UAPA is primarily an anti-terrorism law which prevents unlawful activities, association and maintain the sovereignty and integrity of India. This law is an enhancement of the TADA, Terrorist and Disruptive Activities Prevention Act. It was allowed to lapse in 1995 and the Prevention of Terrorism Act, POTA, was repealed in 2004. The inception of the Unlawful Activities Prevention Act was in 1965 and it was passed in 1967. It aims at effective prevention of unlawful activities associations in India. Unlawful activity refers to any action taken by an individual or association intended to disrupt the territorial integrity and sovereignty of India. Its main objective is to empower the state for dealing with activities directed against the integrity and sovereignty of India. The Act assigns absolute power to the central government. It can declare an activity as unlawful by way of an official gazette. The Act has the death penalty and life imprisonment as the highest punishments. Under the Act, both Indian and foreign nationals can be charged. It will be applicable to the offenders in the same manner, even if the crime is committed on foreign land or outside India. The investigating agency can file a charge sheet within a maximum of 180 days after the arrests. This duration can be extended further after information to the court. UAPA empowers the Parliament to restrict the rights and freedoms of citizens to protect the sovereignty and integrity of India. The UAPA has been amended on multiple occasions to incorporate the changing techniques of terrorism, from shifting the burden of proof to making extraterritorial arrests. This amendment added Terrorist Act to the list of offences, to ban organizations for terrorist activities. Till 2004, unlawful activities referred to actions related to secession and cession of territory. Following the 2004 amendment, the Terrorist Act was added to the list of offences. The UAPA Amendment Act 2019 was reintroduced in the Lok Sabha. The bill was passed by the Rajya Sabha on August 2, 2019. The amendment empowers the central government to designate individuals as terrorists on certain grounds. It empowers the Director General, National Investigation Agency, NIA, to grant approval of seizure or attachment of property when the case is under investigation by the agency. It also empowers the officers of the NIA, of the rank of inspector or above, to investigate cases of terrorism. Earlier, the power to investigate was with the officers of the rank of Deputy Superintendent or Assistant Commissioner of Police only. The main reasons behind UAPA law are maintaining sovereignty and integrity, supporting investigation agencies, increase constitutional support and formation of laws internationally. The Act is criticized for its draconian provisions, which makes it susceptible to misuse. The amendment also violates the mandate of Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. Recently, UAPA Act was trending in news. It was in relation to the arrest of student activists Devangna Kalita, Asif Iqbal Tanha and Natasha Narwal from the Jawaharlal Nehru University. They were arrested in May 2020 in connection with violence in the northeast part of Delhi. The Delhi High Court has granted bail to student activists charged under the Unlawful Activities Prevention Act of 1967. The court clarified the parameters of the otherwise vague Section 15 of the UAPA when delivering the judgment. Let's look at Section 15, 17 and 18 of UAPA. Section 15 engrafts the crime of terrorist action. Section 17 specifies the penalty for soliciting funding to perform a terrorist attack. Section 18 engrafts the offense of punishment for conspiracy to conduct a terrorist action or any action preliminary to committing a terrorist attack. The court pointed towards the blurred line between the constitutionally guaranteed right to protest and terrorist activity done by an individual. The definition of terrorism in Section 15 of UAPA is indefinite and comprehensive, as it covers almost every kind of violent act, be it political or non-political. Under Section 43A and Section 43B of UAPA, the police are empowered to search, seize and arrest any person involved in unlawful activities without a warrant. Under UAPA, the accused does not have the option of anticipatory bail. It presumes the accused guilty solely on the basis of the evidence collected. Accordingly, there are many issues concerned with UAPA. Misuse for curbing political dissent. Against principle of natural justice. Violation of human rights. Undermines federalism. Frivolous charges. Data deficit. In order to prevent the problem of misuse, the government needs to educate the law enforcement authorities. The enforcement authorities should be trained regarding the application and non-application cases of UAPA. Further, they should be made sensitive towards right of dissent in a democratic setup. A public interest litigation, PIL, was filed by Sajal Awasthi against UAPA 2019 in the Supreme Court to declare it unconstitutional as it violates basic fundamental rights. This act compromises with constitutional values such as freedom of speech, personal liberty and the right to a fair trial. Hence, focus must be placed on balancing the security interests with fundamental freedoms granted by the Constitution.